All right, so we're now going to move on to Joseph Bannerman from Bannermans Lawyers. Are you in the room, Joseph?
Yes, I am.
Hello.
How are you,
Um,
Sam?
so obviously, it was interesting because Joseph's going to lead on from Angus Aberdeen's presentation, and obviously they have a very strong mediation element now that's occurring in New South Wales fair trading, because they're understanding that you don't necessarily need to go to NCAT. There's a potential that you can actually resolve the situation quite quickly in mediation. So, Joseph, you're going to take us through some of your tips on how to actually avoid NCAT, and the reasons why you might do that, and other options that might be available for conflict resolution. So I'll leave it to you, Joseph.
Yes. Okay. Thank you, Sam. Next slide, please. And again, please. Um, so today I'm going to be speaking about NCAT disputes and that process, and I'll also be talking about mediation, which is what Sam was talking about, which is a good way to avoid NCAT disputes. Uh, and I also touch on the new process that is available through fair trading if you have building defect issues like common property issues, where you can seek the assistance of and the intervention of fair trading. So if we can just go to the next slide. So mediation is a prerequisite to filing most applications in the NCAT. There are some types of applications, for instance, if a person is seeking the appointment of a compulsory strata manager, mediation isn't required. Or if you're seeking an application for a penalty against the lot owner for a breach of bylaw, then mediation isn't required. But in all other cases, generally mediation is required. And mediation is a very important step because it can resolve the dispute from the outset. And it's very important, as Sam said, to avoid NCAT. Going to NCAT should really be a last resort. Um, uh, we would, because it takes a very long time to get through the process and it's very expensive. And if you get to the end, you may not get the outcome you want, or worse, you may get the outcome you want and the other side may appeal. And I primarily work in this space, and I see a lot of appeals, and it's a very long-winded process. Often, by the time you get to the end of it, you're not satisfied because the legal fees are so excessive, and it's yeah, it's not a happy place to be, and that's why it's important to try from the start to work it out with the other side by trying to negotiate informally first, and then going through New South Wales fair trading. They have very experienced mediators in there, mediators who understand the Strata Schemes Management Act and are very helpful and are very good at resolving these disputes. So it is important uh, to try to use that process. And also, with if you have a building issue, as I was saying earlier, you can go to fair trading and ask them to intervene. And they have powers now, as of October this year, end of October this year, to step in and make orders against an owner's corporation. And the first step to that, my understanding is a mediation process. And then the Office of Fair Trading decide whether or not they're going to take that on. And if they take that on, then there's a whole process they can go through to try to resolve the dispute with the common property issues, the common property repair issues. So if we can go to the next slide, please.
So, Joseph, it's very important to remember, isn't it, that this is not, you shouldn't take any issues within the building personally. Like this is very much like a workplace scenario. If there's issues in the workplace, then there's a process, a system in which to handle it. And if you're conflicted with your personal feelings, then really you should kind of like step aside and allow the other committee members to consider it. Would you agree?
Yes, it's very much, and unfortunately, a lot of these disputes are emotion driven, and they're not. It's a bit like I said, it's a bit like family law because you're living with these people and you're seeing them all the time, and you can't get away from them, and it does become very emotional. And people, dealing with nuisance and things like that, and dealing with moisture and other problems, it does get very emotionally charged, and it's easier said than done, but it's good to try to, take a practical approach to it if you can.
Good advice.
So there's, two main types of orders that you can seek in the tribunal. Interim orders are interlocutory orders, so it's an order associated with a main application. And if you are seeking interim orders, then no mediation is required because it's usually an urgent matter. And it's a typical example would be where you know if a lot owner is carrying out works to common property in their lot without authorization, the owners corporation can very quickly get a cease work order while they seek other relief in the main application. So there are those orders. You have to establish urgency, and then the tribunal will very quickly make those orders. Sometimes within when you file an application, you can get the orders within 24 to 48 hours. So they're very quick orders. And that's a very streamlined process in the NCAT. Next slide, please. And these are the type of scenarios where where interim orders are appropriate or the main orders are appropriate. Again, lot owner carrying out works to common property without approval. And then the reason I'm bringing this up is that I see a lot of applications where the lot owner files interim orders, but they're not really interim orders, and it usually gets dismissed because they're seeking final relief. So that's really what that slide's about, I suppose. Next slide, please. And then just run through quickly the typical disputes that I see in the tribunal, the most common ones. Notice to comply and penalty proceedings, orders for unreasonable refusal to make a common property rights bylaw. Unfortunately, this is actually the single most common dispute in the NCAT. And this is an example where it really should never get to the NCAT because it's something that should be negotiated. And unfortunately, a lot of owners corporations get very particular about when someone wants to do a renovation and they don't agree to resolve the bylaw, and then the dispute arises from there. The next one is the appointment of compulsory strata manager. This is another very common application, which we'll go through in a moment. Orders that the owners corporation repair and maintain common property and damages claims, also very common applications. Typically, there's a water ingress problem, the person has to move out, then they can claim damages and they can also claim for a work order. And then orders for the removal of unauthorized works by a lot owner. So when a lot owner, carries out an unauthorized renovation or puts up an awning or something like that, the owners corporation can seek an order against them. That's what that's about. So I'll just quickly run through these. So I just wanted to show these slides because there's a very intricate process that has to be undertaken in order to be successful, in order for an owners corporation to be successful in getting an order, a penalty against a lot owner. And penalty proceedings are very unusual proceedings in the NCAT because in the Strata Disputes Division, it's the only type of application where the rules of evidence apply. And that means it's pretty much like a court hearing, and it's very strict. And if you get anything wrong, it's all thrown out. But on the next slide as well, please, Sam, is this sort of intricate process that has to be followed in order to to get there. So if you're ever defending one of these as a lot owner, you can usually pick it apart if it's done incorrectly, with all these different problems that may arise. So next slide, please, Sam. And I was touching on earlier, orders for unreasonable refusal to make common property rights bylaw. I have it on good authority that this is the single most common application, and it's quite sad that a person wanting to do a renovation, they're frequently stopped at the process when they go to the owners corporation with the bylaw, and the owners corporation say no. Sometimes the owners corporation has good reason, like if someone wants to put another story on the building or something like that, you can kind of understand them refusing that. But often they're refusing internal renovations, and I find that very sad, because it's, if there's no harm with what you're doing, then there should be no foul. But there are a lot of disputes on this topic, unfortunately. And the next slide, please. So orders for the appointment of a compulsory strata manager. This is a very common application where a lot owner can seek an order to appoint a strata manager who has the power to do anything, basically, without the intervention of the owners corporation. So it's a bit like an administrator being appointed to a company who takes over all the functions. And for schemes that are in very bad shape, they don't have money, they're failing to comply with their duty to repair and maintain common property, they've got a lot of deadlocks on decisions because the people can't get along. In those situations, if you can establish a very high level of dysfunction, and the tribunal can make an order appointing that compulsory strata manager / administrator to come in for a period of 1 or 2 years. And during that period, there's no general meetings, there's no strata committee. Every decision is made by the strata manager simply writing out a delegated note to say, I'm resolving to do this, I'm resolving to do this. And it's obviously a very streamlined way of doing things, because there's no need for any meetings, there's no need for notices to go out, so things can happen very quickly. And yes, those orders do get made quite a lot. We just heard about one of those instances where the compulsory strata manager was in there and they weren't doing the job properly. But yeah, it does happen. So the next slide, please, Sam.
Joseph, may I say that this, in terms of the appointment of a compulsory strata manager, would be unsavoury, right? Because then you're disempowering the owners. So you don't really want to get to this point, do you? You really want to try and resolve matters before you have basically a sheriff in your complex making decisions on your behalf.
Yes, that's right. And you have no say in anything, but it's a very high bar, and the tribunal don't make that order lightly at all. It's a very hard one to get. Then orders the owners corporation repair and maintain common property. This is unfortunately another very common one. A lot of strata schemes don't want to spend money to repair things, unfortunately, and they may just not have the money, and they just I find that when you've got schemes that are high investor percentages, they really don't want to spend the money. And then you get disrepair, and you get water ingress and things like that. And unfortunately, a lot owners jump up and down, beg and scream, and nothing gets done. So they have to go to the tribunal and to seek those work orders. And they can also claim damages, and that is another very common application in the NCAT. Next slide, please. Oh, sorry, go ahead.
I was going to say, like, at the end of the day, if you don't want to spend money, the last thing you want to do is spend it on legal fees, right? So the 100 grand you might spend on legal fees, you actually could have started works on the common property issues. And if you're refusing to allow someone to get the water ingress, kind of like fixed in their apartment, all you have to do is ask yourself, if that was me, would I like to have my apartment fixed? I think you really have to be very personable, don't you, about the whole situation?
Yes, and in addition to that, you've got there's a lot more in expert fees that you would pay, and then there's also the time. If you're fighting for a year, by the time you get a quote a year later, it's always a lot
Yeah,
more. So
exactly.
yeah, it's better to get on with it.
Yeah.
And then there's orders for the removal of unauthorized works by a lot owner. Um, I've been involved in a couple of cases where lot owners have actually done extensions to their lot within their sort of courtyard without any kind of approval at all. And we've successfully obtained orders for the removal of unauthorized works and things like that. So that's another one. If you are a lot owner and you want to do works on property, you have that problem I mentioned earlier where you try to get approval, the owners corporation reject it. Unfortunately, you really need to go through that process and get it approved first, because if you don't have a bylaw, then you can get into a lot of trouble if you do carry out those works. And that is another, unfortunately, very common application in the NCAT.
Well, at the end of the day, if you're living in an apartment building, it's not like you're living in a standalone home, right? Whatever changes that you make to a common property element, and when you say common property, that even means internal to your apartment, because you might be changing load-bearing walls, right? So
Yeah.
you really have to think to yourself. And, I had a situation the other day, the lady said to me, I want to put blinds on, and they're refusing me. And I was like, well, I can come and mediate for you. And she was like, well, what if I just put them up? And I said, well, you can just put them up, but it's like you kind of like not wearing your seatbelt in a car, right?
Yeah.
And what will actually happen is it will annoy these people who are on the committee more, and then what they'll do is they'll take legal action, and then ultimately they may succeed in getting your blinds taken down, and all the angst and all of the issues, that you have gone through, and the disharmony you've created in the building. Surely there's a simpler way of doing it than just going, stuff them, I'm going to go ahead and do it anyway. So, I think people do get frustrated because they're usually empowered people moving into an apartment, and strata can disempower you. But to fight back and actually then, break the bylaws is not the right answer, is it, Joseph?
No, and again, like you have to be very patient, unfortunately, because but you also have to be polite and courteous and try to figure out what their problem actually is, and be and compromise. You've got to compromise sometimes, and it's tough, but that's how it is. And I also foreshadowed appeal proceedings. Um, we get involved in a lot of appeal proceedings, and this is another reason why it's really just very risky, this type of litigation. Going down this path at all, you get to the end. If you win, the opponent's usually very jaded, and the tribunal may have made an error in the decision. It does happen, and they may appeal it, and then they could be successful in appeal and have the whole thing overturned. And it's a horrible long waste of time, and the angst, as you said, and the inconvenience, and the sleepless nights, and then going to court, being cross-examined, going through all that. It's very it's very hard on everyone involved. Um,
I
and
agree.
it's best to try to avoid it by being compromising, being understanding, put yourself in their shoes. Sometimes you just have unreasonable people on the other side. Usually it isn't the case. Usually you just got to figure out what it is, what they want, and then bring them to the party with it.
I agree. But that's where even if you actually are thinking about going down this path of NCAT, it's much wiser to bring in a specialist like yourself or ourselves, to actually try and resolve this. If you resolve it earlier than later, the chances are that you can reach some common ground. If it's got to a point where you don't want to even kind of like, I had a situation the other day where one of the lot owners was basically saying what was going on in their building, and I said to them, you need to have your phone on,
Lawyers, try and keep
Russell,
all
darling, Russell, can you mute yourself
audiences
again, please?
talking
Yes,
about.
so they were walking around with their phone on video in case they were approached by somebody, in the building who was being difficult to them. So that's the last thing you want to do, is be on your guard in your building, correct?
Yeah, that's right. Because it's your home. You don't want to feel like that every time you walk into the corridor, you're freaking out. Am I going to bump into that person? Like, yeah, it is very hard. And it's really worth trying to work things out if possible. So another thing about the NCAT is that you must seek leave to be legally represented. And if the other side doesn't have a lawyer, they can oppose leave, and the tribunal can decide not to grant you leave. And I've had many cases where leave actually hasn't been granted, and my client has had to do the speaking, but I just sort of sit next to them, whisper in their ear, and they sort of speak, which is allowed, which is a bit strange. But the other thing I want to talk about is costs. And in the tribunal, costs does not follow the event, which is the term in the court. Costs follow the event. That means that basically the successful party gets their costs awarded. That means that the other side has to pay a portion of their legal fees, usually about 70%, whatever it's assessed at. But in the tribunal, that position isn't the case unless you have a damages claim, or unless you've got a claim where an amount in excess of 30,000 is being claimed, then costs do follow the event. But otherwise, for all other matters, you won't ordinarily get a cost order. So you'd go through the whole process, spending tens of thousands of dollars on legal fees, and then you wouldn't likely get a cost order. You can get a cost order, but you must establish what's known as special circumstances, which is quite a high bar of very poor conduct by the other party, essentially, or running a very bad case. And in that case, the tribunal may award costs. But even if you do get costs, if they don't want to pay them, you have to go through another process through the Supreme Court, through cost assessment, and it can just take more months and months. And again, you don't want to be chasing that money. You don't want to start this process if you can help it. So you really got to try to head it off at the pass.
Perfectly said. All right, fantastic. Great timing, Joseph. We've got a couple of minutes up our sleeve. So if anyone's got a question, please raise your hand so we can see that. Obviously, we were talking the other day about an example that I had where, this lady had moved into her apartment complex. There was asbestos fencing. She wanted the asbestos fencing removed. She then made an application to the committee to request that the asbestos fencing be removed. Their attitude was, well, it was here when you purchased it. Why are you having such a kitten about it now? And said, no, it's not in our priorities. She took action, went to NCAT. $100,000 later, in legal fees, they were told, you need to replace that fence and you need to do it by this date. And funnily enough, that story came out when we were actually having another one of our conferences in another state. And the lawyer was talking about it, and she put up her hand and said, this is our case study. And I said to her, in hindsight, what should you have done? And she said, we should never have fought. We should never have gone to, the NCAT and actually fought this matter. At the end of the day, we could have actually, as you said, head off the pass and actually had said, oh, well, we understand it's a priority. We've tabled it for month 4. We're now going to do a special levy to raise the funds for it. And it would have actually then all gone away. So, when you're itching for a fight, Joseph, what would you say? What would be your words of wisdom?
But to compromise and try to work it out. But the other thing is that if you get a good specialist lawyer looking at it, he will give you conservative advice. I certainly do. And I say, no, this is not defendable. With that, with that asbestos fencing, I would say, how can you defend this? It's clearly a health hazard. It's not, you're not going to be able to defend it. And I would say, just agree to it. So it's important to get that good specialist legal advice, and because a good specialist won't run a bad case.
I appreciate your honesty, Joseph, as always, and certainly your time today. So the tip is, if you want to kind of like keep things harmonious in your building, start the communication earlier and don't be defensive. And certainly if you have a committee that's not listening, that's when you would engage someone like Bannermans or come to AAA, and we can see if we can negotiate. Sometimes that's what it takes, isn't it? A letter from a lawyer for them to actually realise that you're serious.
And try to speak to them in person. Go to the committee and say, look, can we sit down and work this out? I really, I don't want to fight. I just want to work it out. And if you sit around the table, you probably work it out pretty quickly.
As I say, you attract more bees with honey than you do with vinegar. Thank you,
Yes.
Joseph, for your insights. I appreciate that.
Thank you.
All right. And as this is obviously Joseph's disclaimer.